Hello dear students, myself CA Nikunj Amlani, faculty at Navkar Institute. Today we are going to discuss mock test paper issued by ACCA for your foundation examination to be held in December 2020. And this is the MTP test series October 2020, as you can see in the heading of this page. So it is October 2020 mock test paper, and friends, always the mock test papers are important to be reviewed because it's a kind of paper which can be considered for a final examination. I'm not saying that this paper is going to be asked in the examination in final, but this may be. You should consider the question what is being there. This will be the style in which the paper will be in your final examination. So this is important for us to view. So let us see, friends, the questions as well as answers of mock test paper. And in this video, I'm going to give you the answers for 3 chapters in business law. That is Sale of Goods Act 1930, Indian Partnership Act 1932 and Limited Liability Partnership Act 2008. Remaining 2 chapters, that is Contract Act and Companies Act, will be taken care by a different video and it will be joined over here. So I'm just going to give you the video answers of these 3 chapters. So let us see. Okay. Now friends, in this you can see in your paper actually the instruction will be given there. The question number 1 is compulsory and answer any 4 questions from the remaining 5 questions. You should consider in your paper total 6 questions will be given, and in that question number 1 is compulsory, and out of remaining 5 you need to answer 4 questions. So be very clear on it, read the instruction very carefully and write the paper accordingly. Do not make a mistake in reading the instruction and giving the answer. So it should not happen that you do not write a compulsory question and you write all the alternative questions. It should not happen. So be very clear on what the instruction is and give the answer accordingly. Fine? Okay. Now in question number 1, the first question relates to Indian Contract Act, which I am not going to deal right now. Second question relates to Companies Act, which also I am not going to deal. Question number 3, that is, classify the following transactions according to types of the goods they are. The types of the goods they are asking. Friends, remember the theory, types of the goods. In a types of the goods, we know, actually we made a classification like this. In types of the goods, we are making a classification like this. Existing goods, future goods, and contingent goods. Existing goods means the goods which are in existence at a time of contract. Future goods means the goods which are not in existence, and contingent goods, it means the goods which depends upon uncertain situation or which depends upon contingency. And existing goods are further classified into 3 more parts: specific goods, uncertain goods, and ascertain goods. You know the goods which are already set aside, the goods which are already identified is called as the specific goods. The goods which are not identified, the goods which are just described but not identified, not separated, is called unascertained goods. And when out of unascertained goods you are just identifying, you are setting apart your goods after the contract is made, it is called ascertained goods. You can say specific goods and ascertained goods are similar, but only the difference is time. When you are selecting the goods at a time of contract, it is specific. When you are selecting after the contract, it is ascertained goods. So these 3 classification, you can go like this: existing, future, contingent, and in existing goods, it can be specific, uncertain, or ascertained. That way. Now let us see our question and accordingly, just look at a bifurcation. First one, a wholesaler of cotton has 100 bales in his godown. He agreed to sell 50 bales, and these bales were selected and set aside. First thing, wholesaler has 100 bales in his godown, means the goods are already there. So we can say these are existing goods because the goods are already in his godown. So he is making the contract for sale of existing goods. First thing. Second, out of 100, he is selling 50 bales, and these 50 bales have already been selected and set apart. Selected and set aside, and if it is selected at the time of contract, then we can say it is specific goods. If the goods have been selected and set aside, it is called specific goods. And if it had been selected after the contract, then we would term it as a ascertained goods. Meaning is same. You can say specific or ascertained, both are same, only the time is different. Identified at the time of contract, specific; after the contract, ascertained. So that way it goes. If we look at the answer given by them, just let us have a look at that. There is answer. First one, A wholesaler of cotton has 100 bales in the godown, so the goods are existing goods. And he agrees to sell 50 bales and these bales were selected and set aside. On the selection, the goods become ascertained. We can use the word specific actually. Instead of ascertained, we can use the goods specific goods because it has been identified at the time of contract. That's why it will become specific goods. In this case, the contract is for sale of specific goods. I am again using the word specific goods. As the cotton cells to be sold are identified and agreed upon after the formation. Yeah, they are using the word after the formation of contract. Here actually the clarification is needed. In the question they have not mentioned that it has been identified after the contract or at the time of contract. The language says that the goods are selected at the time of contract. So the confusing part is that you can write your answer subjective. If you assume that goods are selected at the time of contract, it will become specific. And if you assume that it has been selected after the contract, it will become ascertained. As per my opinion, this should be specific goods because it is already selected. So my interpretation is it has been selected at the time of contract and it becomes specific goods. Second, A agrees to sell B 1 packet of sugar out of a lot of 100 packets lying in his shop. See, the person is having a 100 packs of sugar in his shop and out of that he is selling 1 pack. Out of 100, 1 pack. So first of all, we can say it is a contract for existing goods. Yes, it is existing goods because the goods are already in the shop. And out of 100, 1 is to be sold. Now, whether that 1 has been separated, whether that 1 has been selected, no, it is not written over there that 1 has been identified. So only it has been described that 1 out of 100. So it is unascertained goods because it has not been identified, not been set aside. So it is unascertained. So let's see. Second answer, if A agrees to sell B 1 packet of sugar out of a lot of 100 packets lying in his shop, it is existing goods obviously but unascertained because it is not known which packet to be delivered. So it is not set aside, that's why it is unascertained goods. So I hope you are understanding, it's very easy. And the third one, C part, T agrees to sell as all the apples which will be produced in the garden in the next year, which will be produced in his garden this year. Will be produced, you can see the word will be produced, it means the goods are not in existence. So we can say it is a contract for which goods? Future goods. It is a contract for future goods. Okay, fine, future goods. So T agrees to sell all the apples which will be produced in this garden. It is a contract for sale of future goods amounting to agreement to sell. Obviously, future goods because goods are not in existence, so it can never be a sale, it will be agreement to sell. And in the second also it is going to be agreement to sell. In first it may be sell because it is specific goods, depends upon the terms. So this way you need to identify which type of goods it is. I can say very easy part over here to consider. Okay friends, so this was a question number 1C. Now friends, 2.1, that is again contract act, so it will be dealt separately. Question 2, second part. LLP is an alternative corporate business form that gives a benefit of a limited liability of a company and a flexibility of partnership. Explain. See, the question they are asking, LLP gives you the dual benefit. One, that is a limited liability, and second, that is a flexibility of partnership. You remember that we had seen the theory of LLP at the time. We told you that LLP is nothing but a combination of two things, company and a partnership. In LLP, you are getting the advantage of both, certain advantages of company and certain advantages of partnership. So in LLP, what is the biggest duality concept applied here? That in LLP, you are getting the advantage of limited liability concept as well as you are getting the flexibility of partnership form. That is advantage what is being here. So that we need to explain. So let us see the detailed answer so we get an idea how to write it. Okay, just look at here. 2 points are to be main focused here, limited liability and flexibility. LLP is an alternative corporate business form that gives the benefit of a limited liability of a company and flexibility of partnership. So it's a definition what we have seen, the definition of LLP. The limited liability, every partner of LLP is for the purpose of business of LLP and agent of the LLP, but not the other partners. And the liability of the partner will be limited to their agreed contribution in the LLP, while LLP itself will be liable for full extent of the asset. See, what the situation here is actually, whatever liability belongs to LLP will be paid out of assets of LLP. Read my word. Liabilities of LLP will be paid out of assets of LLP and not the assets of partner actually. So partner is limited liable, not unlimited liable. It means partner will be responsible only up to agreed contribution. If I give you an example, let's say in a LLP, there were 3 partners, A, B and C, and they have agreed to give a contribution of rupees 10 lakhs each. They have agreed to give a contribution of rupees 10 lakh each. And in LLP, the liabilities were increased like anything. Let's say liabilities were 2 crores and against which the assets were only 50 lakhs. So we can say there is a deficiency of 1.5 crores. Deficiency of 1.5 crores. Who will bear this deficiency? Whether partners will bring the amount of deficiency out of their personal properties? Answer is no. But yes, they have to contribute the amount equal to agreed contribution. So their liability will be limited up to 10 lakh rupees each. Each partner will bring 10 lakh rupees from the personal property. They will not bear the deficiency of 1.5 crores, but they will bring the amount of 10 lakhs from their personal property. So their liability is limited up to agreed contribution. That you need to remember very carefully, friends. So that is the biggest advantage you are getting here. And second, flexibility of partnership. The LLP allows its members the flexibility of organizing their internal structure as a partnership based on the mutually arrived agreement. Friends, in a LLP, you are making the LLP agreement, and in the agreement you can specify whatever rights and duties you want to. So all the structure, internal structure, rights and duties and management and everything you are deciding. There are no rules which has been specified for the management for the purpose of governing. So you will decide in the agreement that what you want to follow and what is going to be the structure. So internal governance structure managed by partners by agreement. So that's the biggest flexibility. So no legal rules, no legal formalities. The LLP form enables entrepreneurs, professionals and enterprises providing the services of any kind or engage in the scientific or technical disciplines to form commercially efficient vehicles suited to their requirement. Owing to the flexibility in the structure and operation, the LLP is a suitable vehicle for small enterprises and investment by venture capital. For instance, small enterprises, partnership firms, professionals like us, a chartered accountant, company secretary, all these are just forming the LLPs to get a benefit of flexibility as well as limited liability. So it's a very famous format for the small ventures that you need to consider. So this is the biggest advantage of LLP, what you're getting, friends. Next, the question number 3 first. Miss Lucky, while drafting the partnership deed, taken care of a few important points. What are those points? And also give a list of information to be included in the partnership deed. Friends, the question here they are asking about the partnership deed. When you are forming a partnership deed, what is to be taken care? What is important? What is not important? What is needed? Okay, fine. Let me remind you, Indian Partnership Act, partnership deed is nothing but a written agreement. And you know, the agreement can be oral, can be written, can be implied also. So written agreement is not compulsory. Partnership deed is not compulsory, but you have option. It can be implied, it can be expressed, oral, written, any way around. It is allowed. There is no restriction at all. But when you are going for a written partnership deed, you have to make it in a proper format. The things should be included over there. It should be stamped according to Indian Stamp Act. And it has to be registered as per Registration Act if you are holding the immovable property. That rules we know. So these points is to be taken care, as well as what content should be included. So basic details, the name of the firm, the address, the partners' names and addresses, the business and etc, everything. So let us see in the detailed answer so we come to an idea about it. Okay, Miss Lucky, while drafting the partnership deed, must take care of the following points. No particular formalities are required for an agreement of partnership. That we know. Agreement can be in any manner whatsoever, so no formalities needed. Partnership deed may be in writing or formed verbally. They are asking about agreement actually. The document in writing containing the various terms and conditions as to the relation of the partners to each other is called partnership deed. The definition. When the relations between the partner is put it into written form, it becomes a partnership deed. Partnership deed should be drafted with care and stamped according to the provisions of Indian Stamp Act 1899. So stamping is required. Deed will always be on the stamped paper. It will not be on the normal paper actually, we can say. So the stamp value has to be paid and accordingly it should be prepared on the stamp paper. If the partnership comprises immovable property, the instrument of partnership must be in writing, stamped and registered under the Registration Act. So if you are having an immovable property in the partnership form, the document has to be registered under Registration Act. Just that formality you need to also consider very well. Okay. Now, what information should be included in the partnership deed? So that's the pro forma given here. Name of the partnership firm, name of the partners, nature and the place of the business of the firm, commencement of the partnership, that is when your business commenced, duration of the partnership, the period for which partnership has begun, capital contribution details, profit sharing ratio, admission retirement information, rate of interest on capital drawing loans. It is to be specified in the agreement. Otherwise, you will not get an interest on capital, you will not charge interest on drawing and etc. etc. Provision for settlement of the accounts in the case of dissolution. So when the dissolution happens, how settlement will be made for the accounts. Provision for salary, commission, etc. etc. if anything payable to the partners. And provision of expulsion of a partner in the case of breach of duty. So if there is any partner is breaching the agreement, then you can go for the expulsion. So all these things should be mentioned in the partnership deed. These are the content to be mentioned. Okay, these are just not an exhaustive list actually, this is illustrative we can say. Furthermore details can be included according to the requirement of the partnership and something can be excluded also as per their wish. But these are just illustrative list we can say. Ms. Lucky may add or delete any provisions according to the needs of partnership form. As I told you, it is just an illustrative list. It can be adding more details or it can be deducting some details over there as per their requirement. So this is how the partnership deed is formed. Okay. Next, question 3 subpart 2 is for contract act, friends. So we are not going to see the contract act rules here. Question 4 subpart 1. Yes. That is sale of goods. Nemo dead quote non-habit. None can give or transfer what he does not himself own. State these cases in which the rule does not apply under the provision of Sale of Goods Act 1930. The level of asking the question actually, what they are asking. Nemo dead quote non-habit, the rule, you know, no one can give what one does not have. And that rule is used for transfer of title. Seller can transfer good title to buyer only if seller has a good title. So if I have a good title, then I can pass a good title to you. If I am having no title, then I cannot pass a title to you. So seller's title and buyer's title will be same. Seller can pass same title to the buyer. That's the rule, you know. But there are certain exceptions wherein buyer gets a better title than the seller. Buyer gets a better title than seller in certain circumstances. And that circumstances are such where the buyer is buying the goods in a good faith, keeping the trust on the seller, then even if seller is not having a title or seller is having a defective title, buyer gets a good title. So there are certain circumstances, certain situations, certain cases which are given under exception, which we have to discuss here. So let us see detailed answer, so we get an idea about that. Okay. They have asked exceptions to the rule Nemo dead quote non-habit. The term means no one can give or transfer the goods what does not himself own. That's a general rule they are saying. Exception to the rule and the cases in which the rule does not apply under the provisions of SOGAR as below. Now they are giving all the details here actually. So many exceptions are there. First exception is a sale by mercantile agent. Friends, you know the agent. Agent is working on behalf of principal-agent relationship. Now let me just give you a brief example so you get an idea of what I am saying about principal and agent. Principal gave the goods to agent and saying him that you sell the goods to the customer but don't sell it below 5 lakh rupees. Don't sell it below 5 lakh rupees. So the selling price has to be above 5 lakhs in any case. Agent agreed for the same. But then he sold the goods to a customer for 4 lakh rupees. And if customer bought the goods in a good faith from agent, even if agent is doing wrong, he has authority to sell the goods above 5 lakhs only, but then also he sold for 4 lakh, agent is exceeding his authority, and then also customer will get a good title because he is purchasing in a good faith. So that is an exception what is being applied here. So you can just see the first exception. A sale made by a mercantile agent of the goods or the documents of title to the goods would pass a good title to the buyer in the following conditions. If he was in a possession of the goods or document with the consent of the owner, means agent had possession of the goods with the consent of the owner. If the sale was made by acting in the ordinary course of business as a mercantile agent, means he was acting in the ordinary course of business. He was acting in the normally, means he is acting as an agent in the normal course of business. And the buyer had acted in a good faith and has at the time of contract of sale no notice of the fact that seller has no authority to sell. Means the buyer is not aware about agent exceeding the authority. Buyer is not aware that agent is exceeding the authority. In that case, this exception will apply. The first exception being given over here. So mercantile agent means agent having in a customary course of business as such an authority to sell the goods, consign the goods for the purpose of sale or to buy the goods, to raise the money on security of goods. They are giving a definition of mercantile agent actually. I can say in a simple sense, agent means a person having all authority to do a business transactions. Second exception, sale by one of the joint owners. Now again, let me give you an example so you will be clear about it. One of the car which is owned by 3 owners, A, B and C. All these 3 are the owners of the good. One fine day, B and C handed over a car to A and said that you take care of the car. And B and C just went out for some walk. And then A sold the car to Mr. X for 5 lakh rupees. And who bought the car in a good faith from Mr. X. See, actually the ownership belongs to 3 persons. So car should be sold by all the 3 persons jointly. But here A alone sold the car to X and X bought the goods in a good faith. So even if the joint owner has not authority to sell the car, but X will get a good title because he is purchasing in a good faith. So that is another exception being applied here. If one of the several joint owners of the goods has the sole possession of them with the permission of the others in a property, in a goods may be transferred to any person who buys the goods from such a joint owner in a good faith and does not at the time of the contract of sale have a notice that a seller has no authority to sell. See all the things they have told here actually. Here A is selling the goods to X, but A is having a possession with a permission of B and C. B and C had given a possession to A with their free consent. Possession was given and that's why A sold the goods to X. So no doubt here A is exceeding his authority, A is doing some wrong, but X will get a good title because he is acting in a good faith. Third, sale by a person in possession under a voidable contract. Now voidable contract, how it happens, let me again give you the example. X sold goods to Y, so goods delivered to Y, X paid the amount. But actually the money was given as a fake currency. A fake currency, it means Y has done a fraud with X. So this contract is treated as a voidable contract. And on this basis, X wants to cancel the contract because the fraud has been done by Y. But before X could cancel the contract, Y sold the goods to Z and Z purchased the goods in a good faith without any knowledge of this previous fraud, and that's why Z will get a good title. So this is another exception applied here. Look at this. A buyer would acquire a good title to the goods sold to him by the seller who has obtained the possession of the goods under a contract voidable on the ground of coercion, fraud, misrepresentation or undue influence, provided that a contract has not been rescinded until the time of sale. Not rescinded. It means before X could cancel the contract, Y sold the goods to Z, and that's why this exception applies. Okay. Another exception, sale by one who has already sold the goods but continues in a possession thereof. Dual sale we can say. Dual sale. How it works? Okay. X sold the goods on 1st January 20 to Y. Let's say property has been passed but possession remains with X. Delivery was to be given on 5th January. That was decided. On 1st January, goods are sold, possession remains with X because delivery was to be given on 5th. On a 2nd January, Z was interested in buying the same goods. So X sold the goods to Z for a double price almost. So he gave the goods, took the money, and the matter was over. Z, while purchasing the goods, was not aware regarding the previous sale. Means Z is not knowing that the goods are already sold to Y. Z was not knowing that goods are already sold to Y, and that's why he bought. So we can say Z is buying in a good faith, and that's why he will get good title. Now we will ask a question, what about Y? Friends, the contract with Y is going to be cancelled even if property was transferred. And in that case, Y will be able to claim damages from X. That way it will work. So dual sale, actually X is making a dual sale of the goods, we can say, and that is possible because possession was still with X. If a person sold the goods but continues to be in the possession of them or of the document of title to them, he may sell them to a third person, and if such person obtains the delivery thereof in a good faith without notice of the previous sale, he would have a good title to them, though the property in the goods has passed to the first buyer earlier. A pledge or other disposition of the goods or document of title by the seller in possession are equally valid. So they are saying a seller once has sold the goods, but he is having still the possession of the goods, so he can sell the goods to another buyer, and another buyer can buy in a good faith, and transaction will be valid. No doubt the seller is doing a breach of the contract here, and that's why he will be liable for the damages. That is for sure. But the another sale, what is being happening here, it will be valid on the basis of good faith. Sale by the buyer obtaining possession before the property in the goods has vested in him. Here they are saying actually the buyer is selling the goods before getting property. How it works? X sold the goods to Y, given a delivery, so it means the possession has been received by Y, but there is a condition that when Y will pay the amount, then only property will pass. So payment and property both are pending actually. Possession has been given, but payment is not made, and that's why property has not been passed. Now, Y sold the goods to Z before getting property actually, because payment is not made, so he has not got a property, but Y sold the goods to Z and Z bought in a good faith, without knowledge that Y has not got a property and still Y has not paid the amount and etc. etc. So Y sold the goods to Z and Z bought in a good faith, so Z will get a good title here because Y had got a possession of the goods and he can sell the goods. Okay, so that is another exception. Where a buyer with the consent of the seller obtains a possession of the goods before the property in them passes to him, he may sell, pledge or otherwise dispose of the goods to a third person, and if such third person obtains the delivery of the goods in a good faith and without notice of the lien or the right of original seller in respect of the goods in good faith, and without notice of the lien or right of original seller in respect of goods, he would get a good title to them. So all the story they have just mentioned here, what I told you, that buyer has got a possession but he has not got a property, and then he is selling the goods to another buyer. The another buyer is buying the goods in a good faith, and that becomes a basis for valid contract. Sale by unpaid seller. You know friends, when you become an unpaid seller, you are having a right of lien or stoppage in transit, and once you go for right of lien or stoppage in transit, then you can resell the goods if the buyer do not pay the price within reasonable time. Where the unpaid seller who has exercised the right of lien or stoppage in transit resell the goods, the buyer requires a good title to goods as against the original buyer. That detailed discussion is given in unpaid seller topic. You are not supposed to write the detailed discussion here. You only mention this much point. Sale under other provisions of the Act. In that first, sale by official receiver or a liquidator of the company will give the purchaser a valid title. So official receiver or a liquidator. Official receiver comes into picture in the case of insolvent person. The liquidator comes into picture in the place of company. So when a person becomes insolvent, his settlement is done by official receiver, and when a company is liquidated, the liquidator comes into picture for the purpose of settlement. And that gives the right to official receiver or liquidator to settle the things. Second, purchase of goods from a finder of the goods will get a valid title under circumstances. Finder of the goods, actually you have discussed in the Indian Contract Act, even a finder of the goods is a duty to find the true owner and give the goods back. But if the true owner is not found, then the finder can resell the goods. If the true owner is not found, then finder can resell the goods to anyone under certain circumstances. You know the circumstances you already seen in the quasi contract actually in the Indian Contract Act. And sale by pony under default of the owner will give a valid title to the purchaser. Pony owner, that's a pledge transaction they are talking for. In a pledge of the goods, if the owner do not pay the amount due on the due date, that is a default is made, then the pony has a right to sell the goods pledged for the purpose of recovery of the loan amount. So this right is given to him. So we can say all these points being considered here, somewhat a long question, but you need to write in time. So be very clear friends, if this question is being asked, you need to write all the points very precisely and in time. So just remember the points very carefully. Okay. Next question number 2, partnership question. Messrs XYZ and Associates, a partnership firm with the 3 partners X, Y and Z, as a senior partners were engaged in the business of a carpet manufacturing and exporting of the foreign countries. On 25th of August 2018, they introduced Mr. G as an expert in the field of carpet manufacturing as their partner. On 10th January 2020, Mr. G was blamed for unauthorized activities and thus expelled from the partnership by approval of all the partners. See, XYZ 3 were already partners in the firm, carpet manufacturing. Mr. G was an expert in the carpet manufacturing, and that's why all the 3 partners admitted Mr. G into the partnership. So G was admitted in 2018. Then in 2020, all the 3 partners blamed that Mr. G is doing an unauthorized activity, and that's why they jointly want to expel G out of the firm. So first question they are asking, whether examine whether the action by the partners was justified or not. Whether they are asking that whether this expulsion is justified. Answer is yes. Why? Because according to the 3 partners, the activities of G are unauthorized, which is not good for the partnership firm. So activities of G are not in the interest of the partnership firm, and that's why they want to expel G out of the firm. That is fine, they can expel. There is no problem at all. So expulsion is allowed, but subject to conditions. Now the second question they are asking in the same way, what should have the factors to be kept in mind prior to expelling a partner by the firm by the other partners according to the provisions of Indian Partnership Act. Now what factors to be considered for expulsion? When expulsion will be valid? Friends, you know the 3 conditions for the expulsion. Majority of the partners has to be agreed, expulsion provisions should be there in the contract, and expulsion has to be in a good faith. So all the provisions are there. Let us see the answer in writing. Okay. Expulsion. A partner may not be expelled from a firm by majority of the partner except in exercise in good faith the powers conferred between the partners. Good faith. If it is good faith, then expulsion is valid, otherwise not. The test of good faith under section 33 subsection 1, meaning of good faith is given. The expulsion must be in the interest of the partnership. Here, whether interest of the partnership is there? Yes, it is there. The partner to be expelled is served with a notice. You have to give the notice to G that you are doing unauthorized activity, and that's why we want to expel you. And he is given an opportunity of being heard. Opportunity of being heard, that is to represent yourself. He is given an opportunity to represent. See, you have to give an opportunity to G to represent himself, and he will prove that he has not done a fraud. So that is to be proved by him. If the partner is otherwise expelled, the expulsion is null and void. So if you are not following these conditions for the expulsion, expulsion is going to be null and void, and the partner whom you want to expel will not go out of the firm, will be again rejoining the firm, and it will go on as it is. So the question here they are asking, friends, that whether intention is valid. Yes, it is valid. Action by the partners of Mr. XYZ and Associate, a partner to expel G from the firm, was justified as he was expelled by the approval of the other partners, exercising the good faith to protect the interests of the partnership against the unauthorized activities charged against Mr. G. A proper notice and opportunity of being heard has to be given to Mr. J. So all the conditions to be fulfilled here. Reason is okay, reason is perfect, that he is doing unauthorized activity. So the reason to expel him is in the interest of the foreman. That's why expulsion is allowed. But you have to satisfy the conditions what is mentioned here. The following are the factors to be kept in mind prior to expelling a partner from the firm by other partners. So what they are saying? Prior to expel, this points has to be considered. That's the same thing what you read about. That's good faith actually. The power of expulsion must have been exercised in a contract between the partner. Expulsion power has to be there in the contract. The power has to be exercised by majority of the partners. So majority partner must agree for the expulsion. And third, it has to be exercised in good faith as we see in the above provision. So all these conditions should be fulfilled for the purpose of exercising the expulsion right. Then only expulsion will be valid, otherwise it will not be valid. Next question, question number 5 first. Soga question. Okay. A, who is the agent of the buyer, underline the word very carefully, had obtained the goods from the railway authorities and loaded the goods in a truck. In the meantime, the railway authorities received a notice from B, the seller, for the stopping the goods in the transit as the buyer has become insolvent. Referring to the provisions of Sale of Goods Act 1930, decide whether the railway authorities can stop the goods in transit instructed by the seller. Friends, so very interesting story actually they have given here. Now let me explain you. Friends, A is a buyer and B is a seller. Seller, buyer. Now, seller send the goods through a transport, let's say a railway. Through railway, the goods have been sent. The railway department has taken the goods, they reached the destination. So, A sent his agent for the purpose of picking up the goods from railway department. So, railway department handed over the goods to the agent. And agent just had come with a truck. So agent put the goods in his truck, took the goods from railway authority. But before agent could run from here, B got a notice. What? That A has become insolvent. Now it is a very big game played with Mr. B. A has become insolvent and B got a notice of it. So B immediately sent a notice to railway department that you don't give a goods to buyer and stop the goods there only. I want the goods back. So B wants to stop the goods in transit. Stoppage in transit they are asking. Now whether stoppage in transit is possible? Friends, conditions for stoppage in transit. First, goods has to be in transit. Second condition, buyer has to be insolvent. And third condition, seller has to be unpaid seller. Okay. Whether buyer is insolvent? Yes. Whether seller is unpaid seller? Yes. Whether goods are in transit? No. Why? Because already goods has been taken by agent. Buyer's agent has already got a position. Buyer's agent has already got a position. And once the agent gets a position, it means ultimately buyer has got a position. A possession is already received by buyer or buyer's agent. It's one and the same thing. So transit is ended. And transit is ended. So stoppage in transit is not possible. So B cannot stop the goods in transit. I hope you are understanding this story as a whole. Okay, let us see the answer. The right of stoppage of the goods in transit means right of stopping the goods after the seller has parted the goods. Thereafter, the seller regains the possession of the goods. That's a definition they given actually. You given the goods to the transit, then you stop the goods and you get it back. This right can be exercised by unpaid seller when he has lost his right of lien over the goods because the goods are delivered to the carrier for the purpose of taking the goods to the buyer. This right is available to unpaid seller only when the buyer has become insolvent. Goods has to be in transit, buyer has to be insolvent. The conditions necessary for exercising the right. The buyer has not paid the total price. The seller has delivered the goods to the carrier. The buyer has become insolvent and the goods have not reached the buyer. They are in the course of transit. So all these conditions have to be fulfilled for the purpose of exercising stoppage in transit. Now in the given case, A, who is an agent of the buyer, had obtained the goods from the railway authorities and loaded the goods in the truck. After this, the railway authorities received a notice from B to stop the goods as the buyer had become insolvent. But friends, according to the provisions, the railway authorities cannot stop the goods because the goods are not in transit. A, who has loaded the goods on the truck, is an agent of the buyer. That means the railway authorities have given the possession of the goods to the buyer, and the transit comes to an end when the buyer or his agent takes the possession of the goods. Very beautifully they have given the answer, I can say friends. Actually, possession is already given to the agent and possession given to agent, it means possession given to buyer. And once the possession is given to the buyer, the transit is ended. And because transit is ended, stoppage in transit is not possible anyway. Fine. So this is your answer. Now friends, 5 second is a Companies Act, so I am not dealing right now. 6.1 is a Contract Act, so I am not dealing right now. Yes, 6.2, yes, we are going to deal. It's a Partnership Act. When does a dissolution of a partnership form takes place under provisions of Indian Partnership Act 1932? So the question they are asking, when dissolution of firm takes place? So the different modes of dissolution. The question they are asking is modes of dissolution. Very easy. Modes of dissolution. Very easy question. Okay, let's go to the answer, friends. Answer, here it is. Dissolution of the firm. Okay. Dissolution of the firm means discontinuation of the dual relation between all the partners of the firm. You know, we had seen the two words, dissolution of partnership, dissolution of firm. So when some of the partners go out of the firm and the remaining partners continue the firm, it is called dissolution of partnership. But when all the partners get separated, business is closed, then it is called dissolution of firm. So when all the partners get separated, that's important, that's dissolution of firm. But when only one of the partner retires or becomes incapacitated from acting as a partner due to death, insolvency or insanity, the partnership, the relationship between the partners and others is dissolved, but the rest may decide to continue. In such cases, there is in practice no dissolution of firm. The particular partner goes out and the remaining partners carry on the business of the firm. In that case of dissolution of firm, on the other end, the whole firm is dissolved. The partnership terminates as between each and every of them. They are giving a clear difference between dissolution of firm and dissolution of partnership. Again, I am just reminding you the thing. When, let's say, one of the partner or few of the partner goes out of the firm, and remaining partner continue the business of the firm, it is called dissolution of partnership. Like a partner retires, a partner dies, a partner becomes insolvent, any of the case. In that, it becomes dissolution of partnership because the firm continues, the business continues. That's why it is called dissolution of partnership and not a dissolution of firm. But on the other side, when all the partners get separated, when the business is discontinued, it is called dissolution of firm. So both are quite different. Just be very clear on it. Okay. Now, dissolution of firm. We are going to just see the modes of dissolution, how it will happen. Different cases are there. First, as a result of agreement between all the partners, that is called dissolution by agreement. Friends, you know, a partnership is created by the agreement. So in the same way, it can be dissolved by agreement. All the partners will agree to dissolve the firm. All the partners agree to dissolve the firm, that is dissolution by agreement. So if all partners give their unanimous consent to dissolve the firm, it will be dissolved automatically. There is no problem at all. Second, adjudication of all the partners or all partners but one as an insolvent, which is compulsory dissolution. Okay, what they are saying, friends, let us say in a partnership firm there are A, B, C and D, 4 partners in a firm. Now let us say all of them are declared insolvent. All of them are declared insolvent. Whether firm can continue? Answer is no. Compulsory dissolution, no option at all. Who will run the firm? No one. Okay, fine. A, B and C got insolvent and D only is solvent. Will the firm continue? Again, answer is no. Because D alone cannot run the firm. Okay, A and B declared insolvent, C and D are solvent. Can the firm continue? Yes, because two partners can run the firm. So first situation, all the partners insolvent. Second situation, all are insolvent except one. So in both the situation, there will be compulsory dissolution, no option at all. Next, by the business of the firm becoming unlawful, there is also compulsory dissolution. Firm's business becomes unlawful. Let's say you are running a liquor business in Maharashtra, Mumbai, or in Rajasthan. Okay, it's valid, allowed, you can do it. You are running a liquor business in Rajasthan or in Maharashtra, it is valid. But now, let us say government has declared that liquor selling is prohibited in all India. Now, a business will become illegal. So, you have to dissolve the firm. You have no choice. Subject to agreement between the parties on happening of certain contingencies. Contingencies like such an event. That is first, affluence of time. There is a fixed period partnership. Partnership entered for the 5 years. 5 years completed, dissolution of firm. Completion of venture, which was entered into particular partnership, which is entered for a particular contract, particular venture. So when the venture is done, completed, partnership dissolved. Death of a partner, any of the partner dies, the firm is dissolved. Insolvency of a partner, when any partner becomes insolvent, the firm is dissolved. So these are the events. Next, by a partner giving a notice of his intention to dissolve the firm at a partnership at will, and the firm is being dissolved from the date mentioned in the notice, or if no date is mentioned, then from the date of communication of the notice. If it is partnership at will, then any of the partner can dissolve the firm by just giving a written notice. Any partner can dissolve the firm by giving a written notice. Notice will be given to all the other partners and the firm will be dissolved. Just the notice is to give, nothing else. Give the notice, matter is over. Fine. And whatever date you have mentioned in the notice, from that date the dissolution will be effective. And if no date is specified, then the date on which the notice reaches to all the other partners, that is the date of communication. Next, by intervention of the court in the case. Intervention of the court. See, many a time what happens actually, partner just applies to the court for dissolution for certain situation, for certain circumstances. And looking to that circumstances, court will issue an order of dissolving the firm. So these way the sequence goes actually. Partner applying to the court and court giving the order of dissolution. So we are going to see the situation or the circumstance under which court will give the order for dissolution. Okay. First, a partner becomes unsound mind. So let's say in a firm actually there are many partners, but one of the partner who is a main partner becomes unsound mind. One of the partner who is a main active partner becomes unsound mind. So the remaining partner want to dissolve the firm because they cannot run it anymore. Permanent incapacity of a partner. If a partner becomes permanently incapable, like he becomes blind, or he becomes like let's say he goes into the coma, he just gets a huge accident and due to which he cannot work for the firm. So these all are the situations where other partners will wish to dissolve the firm. Misconduct of the partner affecting the business. So any of the partner is doing a fraud or working in a wrong way, actually doing like say gambling activities or doing like this, which is not good for the firm. Misconduct, fraud, then in that case they can go for the dissolution. Willful or persistent breach of agreement by the partners. Breach of agreement. They are doing a breach of agreement, they are breaching the agreement, and that's not possible. Not possible to run the firm with a dead partner, so they can go for the dissolution. Transfer or sale of the whole interest of a partner. If a partner transfers all of his interest to other partners, if a partner transfers all of his profit sharing to other partners, then it will be a reason for dissolution. Improbability of the business carried on save at a loss. It means the business can be carried only at a loss. The firm is incurring a huge losses, and in the future also the profit is not expected. In that case, it can go for the dissolution. And the court being satisfied on other equitable grounds that a firm should be dissolved. So other than these also the reason can be there where court will be willing to dissolve the firm on justifiable reasons. If the partner proves that it's justifiable to go for dissolution, they can go for order of dissolution. So these are the different cases, different modes on which the firm will be resolved. You need to remember all the points very carefully. They are asking the question very frequently, the modes of resolution. So remember all the points and give the answer very perfectly. Okay friends, so here actually we end up with all the questions of Sale of Goods Act, Indian Partnership Act and LLP Act 2008. Again friends, I am saying refer all the questions very carefully and see how they are asking the question in the examination and how you need to write the answer. And I hope it will be very much perfect for you. It will help you a lot for the examination. Thank you very much and all the best.
Hello students, I am Jyoti, Sachdev, Choksi. Hopefully you all are doing well, and today we are starting with the MTP of November 20, which is launched in October 2020, and we are starting with the subject of law. And in law, firstly we are starting with the Indian Contract Act 1872. Okay, see the format. Normally the students ask, the format of law paper is like this. Question 1 is compulsory and there will be remaining 5 questions from which you need to attempt any 4. So you can skip one question from the remaining 5 questions. Question 1 would be compulsory in the exam. So keep that in mind. We are starting with question number 1. In question number 1, the first point, XYZ jointly borrowed. Jointly borrowed. So it is the provision of joint promisors governed by section 42 of the Indian Contract Act 1872. As and when you start with a question, start reading the question, the provision should be coming in your mind. So the provision is liability of joint promisors, which is governed by section 42. Okay, so XYZ have jointly borrowed 1,50,000 from A, and the whole amount was repaid to A by Y. Is it possible? The promise is given by 3 people jointly, that is X, Y and Z, and the entire payment is made by Y. Is it possible? Yes, because they are liable jointly and severally. So any one promisor can make the entire amount payment. So payment made is correct. Okay. Decide in light of Indian Contract Act 1872 whether first Y can recover the contribution from X and Z. See, we'll just form an example for it for better clarity. So it is a question relating to liability of joint promisors. It is a question relating to liability of joint promisors governed by section 42 of the Indian Contract Act 1872. Okay. So, forming an example, the parties are A, B and C, and these 3 people have jointly promised whom? X, Y and Z. In our example we took A, B and C, but here it is X, Y and Z, and they have made a joint promise to A to pay what amount? What amount is to be paid? That is 1,50,000. So amount to be paid is 1,50,000. So unless anything contrary is provided, unless anything contrary means if it is specifically written the liability of X is 60,000, Y is 40,000 and Z is 50,000, then that provision would apply. But if no specification is given, then they will be liable in equal ratio. As we had studied, they will be liable in equal ratio. So here the liability of X, Y and Z would be 50,000 each. The liability of 3 of them would be 50,000 each. So now in the question it is mentioned that this party Y. Now Y has made entire payment to A. Y has made entire payment of 1,50,000 to A. Now can he recover the amount from X and Z? So answer is yes. Y will recover 50,000 from X and 50,000 from Z. Okay. So Y has the right in case a particular person is made to pay the whole amount, he has the right to recover the contribution from others. So here there would be answer Y is entitled to recover 50,000 from X and 50,000 from Z. Okay. So that is the answer to the first question. Can Y recover the contribution from X and Z? So answer to the first one. Answer to the first one, yes. Y can recover 50,000 each, rupees 50,000 each from X and Z. Okay, that right is available to Y, and if they do not pay, then he can file a suit. Okay. Second question which they have asked, legal representative of X are liable in case of death or not. So if there is death of a party who is X, then legal representative will be liable or not. So see, we have studied under the provision of joint promisor that the joint promissors are liable to pay the amount, and if there is a death of any one of the joint promissor, then his legal representative will be liable to pay. So here in this situation, if a party dies, let's take an example, X is dead. So after his death, his legal representative will be liable on his behalf. Okay, so again in the second question, the answer would be yes. Legal representative of X would be liable. Of X would be liable. Okay, and what if all the joint promissors are dead? Then representative of all would be liable to pay. So in death, liability goes to legal representative. Okay, and the third question asked, Y can recover the contribution from assets in case Z becomes insolvent. Can recovery be made from assets, property, in case Z becomes insolvent? See, in the first situation, they said Y has paid the entire amount. Okay, so Y can recover from X and Z. What if X dies? Then Y can recover the amount from his legal representative. Now they are saying that this party Z is becoming insolvent, bankrupt. Then can Y recover the amount from his property? Tell me, yes or no? In insolvency, is property liable or not? Answer is yes. Okay, so in case Z becomes insolvent, then the recovery can be made from Z's asset. Okay, so in case of death, who is liable? Legal representative. And in case of insolvency, the recovery can be made from the assets. Okay, so again to the third question, the answer is yes. Y can recover the amount from Z's asset. So in case of death, who is liable? Legal representative. And in case of insolvency, the property would be liable. So these are the three answers to the first question. Okay, just note it down there. Done? Is it clear? Section 42, liability of joint promissors. Whenever there is a practical question, I have told you before also, make a basic rough chart of it. So it would be clear that who is liable to whom, what amount the party is liable. Okay? Done? Going to the next question. Next question of Contract Act. See, this first question is of 4 marks. First question is of 4 marks. And there are 3 different questions asked. So initially, first you need to write the entire provision of joint promisor. You don't need to write the provision, the facts and the conclusion 3 times. Okay, it is only one question. So firstly, write the entire provision of joint promisors, that joint promisors are liable jointly and severally. In case of death, the legal representative would be liable, and in case of insolvency, the property would be liable. Section 42 provision. Okay. After that, facts of the case. What is asked to you? The 3 questions must be mentioned, but in summarized format in 3 to 4 lines. That's it. And finally, the conclusion. And conclusion must be given by applying the above provisions of Contract Act. Up to the current case, the answer is this, and the 3 answers must be mentioned separately, A, B and C, and the length should be around 1 page for 4 marks. Okay, clear? Next question of Contract Act is question 2, first one. Okay, before deciding question 2 to attempt or not, just check the remaining questions, which question you need to skip. Decide it first and then go for question 2. Okay, so starting with question 2, first one, anticipatory breach of contract. Anticipatory breach of contract is a breach which is done before the time for performance has arrived, and discuss the effect of anticipatory breach on contract. And the weightage is very high, like the provision in the module is available of around half page, and the weightage given is 7 marks, that is too much. So you need to write whatever you know about anticipatory breach. So see, starting with the anticipatory breach concept. Whenever there is breach, you need to remember Sonu Nigam, right? Anticipatory breach of contract. Okay, so anticipatory breach of contract is a breach which is done prior to the due date of performance, before the performance date has arrived. Okay, so we will write it down, the explanation of anticipatory breach. Anticipatory breach is done before the date of performance arrives. So as I told you, the performance date was 31st and the breach is done on 27th. So it is known as an anticipatory breach of contract. Okay. It is done prior to the date of performance. So you need to explain first what is anticipatory breach. Initially, you need to start with that breach of contract is of 2 types, actual and anticipatory, and in one line just explain it, and then start with the concept of anticipatory breach. Also, anticipatory breach, you need to explain that it can be express, also it can be implied. Express means by words, and implied means by conduct, by behavior. As I gave you the example that Sonu Nigam calls us on 27th and says I will not be able to come on 31st. That is an express breach. So that is known as an anticipatory breach, which is done in an express manner. Okay, so you need to write anticipatory breach can be done in an express manner by words, oral or written. Also, Sonu Nigam didn't inform on 27th, but he went for a world tour or he made a contract with someone else on 27th. So we know he won't come to our place. So that is implied. So it can be done in an implied manner also by his conduct or behavior. Okay, so you need to clarify or make understand both the points, that it can be done in express manner also and implied manner also. And they have asked us, that is the important part which I have told you before also. Effects of anticipatory breach. Okay, when you are explaining express or implied, do explain with certain example. okay, because you need the content in exam because it is of 7 marks, okay. So do explain it with example. So you need to explain the concept of breach and anticipatory breach in 1 page, and in the next page you will go for effects of anticipatory breach. As I told you, if Sonu Nigam does breach, then the other party has 2 options. The manager has 2 options. He can cancel the contract on 27th, or if he wants, he can wait till 31st. Okay. So these are known as the effect of anticipatory breach. So effect of anticipatory breach will be as follows. The other party is having 2 options. You need to write that initially, and 2 options are: first, resign the contract. In place of cancel the contract, we use the word resign the contract. Resign the contract and sue the other party, that is, file a suit on Sonu Nigam for damages due to the loss suffered by the manager, okay. Or second, not and, it is or, choose one, okay. Elect means decide not to resign the contract. So manager is deciding not to resign the contract on 27, not to cancel the contract, and treat the contract as alive. Treat the contract as alive means the contract is kept valid, it is not cancelled, and wait till the time of performance arrives. So he chooses to wait till 31st. So in first option, he is cancelling it on 27th and filing a suit for damages. In second one, he is waiting till 31st. Okay. So these are very important effects of anticipatory breach. Either cancel or wait. Okay. So see, you know the 2 options, manager has 2 options, cancel or wait, but how you interpret, how you write it in exam is very important. Okay. So just go through it and note it down. Okay, initially you need to start, as I told you, breach of contract is governed under the provisions of Indian Contract Act 1872, and breach means when the party breaks the terms and conditions of a contract. Breach is of 2 types, actual and anticipatory, and then you will jump to anticipatory. Okay. If it was for 3 or 4 marks, no need of mentioning breach or types of breach, but 7 marks you need to mention some lines on it. Okay. Anticipatory breach explanation, express implied with example, and most important, effects of anticipatory breach. Please note it down there. Okay, if you would use the word cancel in place of resign, you will get marks but less marks. So you need to use the important words as it is. Resign the contract and sue the other party for damages. Elect not to resign. If you directly start with wait till the date of performance, you will get the marks but marks will be less. If you use the words that are given in module, you will get more marks for it. Okay, so whatever important questions are there which you have already ticked to be important, try to remember the words, the important words given in the module. Done? Clear? Okay, so we are done with question number 2 first, which is of 7 marks, and in that we require to write a content of 1.5 page. Okay, around 1.5 page is required for anticipatory breach and its effects. Okay, next question of Contract Act is question 3 second, which is relating to minor. So we are starting with the question 3 second question. Vikas aged 16 years, so he is a minor. When you see minor, the contract is void ab initio. If it is for benefit, then it is considered to be valid. Okay, that should be clear in your mind. 16 years he is studying in an engineering college. On 1st March 2019, he took a loan of rupees 2 lakh. Normally, when it comes to a mind that minor has made a contract, the answer would be void ab initio. But we need to check for what purpose the loan is taken by the minor. So he has taken loan of 2 lakh from Rahul for the payment of his college fees. Now that is education. So he has done a transaction for the purpose of necessaries. Education, medical treatment, food, clothing, shelter, these all are necessaries, basic requirements. And as per law, if a person is supplying the minor with basic necessaries, then minor's property is liable. Did minor make a contract that my property will be liable? No. That is liable by law. Which contract? Quasi contract. First one, quasi contract. Necessaries supplied to minor, his property will be liable. Okay, so if it is a college fee, it is education, and so it becomes a necessary, and so property would be liable. So it is not void ab initio, it is considered to be valid. Okay, and he agreed to pay it by 30th May, and he possesses assets. See, he has assets, he has property, so no issue. He has property of 15 lakh, loan taken is 2 lakh, so it would be sufficient to repay. On due date, Vikas fails to pay back the loan. So he is not paying back the loan. Rahul now wants to recover the loan from Vikas out of his assets. Decide whether he would succeed, referring to the provisions of Indian Contract Act 1872. The clear answer is yes. Clear answer is yes. Okay. We'll just note it down. See, normally a contract with a minor is void ab initio. Normally a contract with a minor is void ab initio, and court will never enforce such contract. Court will never enforce such contract. Means the other party cannot file a case on minor and demand the recovery of the amount. So court will never enforce such contract because it is void ab initio. But under an obligation imposed by law, under an obligation imposed by law. What is an obligation imposed by law? For example, I told you I forget my mobile phone in the class and you get it. There is an obligation on you which is imposed by law, not by me. I didn't tell you to return it back, but the law has imposed an obligation on you to return the mobile phone back to me. That is nothing but quasi contract. Same way, the minor has an obligation which is imposed by law. He needs to repay from his property. Okay, obligation means duty. So under an obligation which is imposed by law, if a person has supplied with necessaries, to a minor, then he can claim reimbursement. Reimburse means to pay back, to get it back. reimbursement from minor's property. So if there are necessaries supplied to minor, if a person has supplied some necessaries, food, education, medical treatment, clothing, then he can get the amount back from minor's property. But there is no personal liability. There is no personal liability of a minor. Okay, so minor is not liable. What if he didn't have property? What if the loan given is 2 lakh and he has the property of 1 lakh? So for remaining 1 lakh, is minor liable? Answer is no. There is no personal liability of a minor. Okay, so that is a provision which you need to write of around 1 paragraph. Then facts of the case is given in the question. So loan is borrowed by the minor of rupees 2 lakh for college fees, which is necessaries. So that is the basic facts of the case. The other party want to file a case and recover the amount. And the conclusion. So as per the provision of quasi contract. So as per the provision of quasi contract, minor's property is liable for the necessaries supplied. For the necessaries supplied. As per the current case, property is sufficient. You need to check, is the property there or not to repay the debt. So here the property is sufficient to repay the loan, and so minor's property is liable. And so minor's property is liable because the loan is 2 lakh and the property amount is very high. So the property is sufficient to repay the loan, so the property will be liable. And the final line of conclusion, what have they asked you in the question? Rahul now wants to recover the loan from Vikas out of his assets. Answer with yes or no. Can Rahul recover the loan from his assets? Answer is yes. Rahul can recover the loan amount or loan of rupees 2 lakh from assets of Vikas. Okay, so that is the final concluding line. Clear? I have mentioned some extra points in this answer so that you have the content to write. Okay, you should have the content to write in the exam. Not only for necessaries, property is liable. You should explain that under an obligation which is imposed by law, that is nothing but quasi contract. If a person has supplied with necessaries to a minor, then he can claim reimbursement from minor's property. Okay, so the same sentence can be framed in 1 line also. The same can be framed in 5 lines also. So it will depend on the marks, what content you should write. Okay, clear? You want to note it down? Just note it down. This second point is important. Okay, and then the conclusion. Applying the above provision or as per the provisions of Choksi contract or the Indian Contract Act 1872, whatever you wish to write. This line is important. This you need to write. Property is sufficient to repay the debt. Okay, so divide the answer into three parts. As you know, provision, as we mentioned above, that for his if you have supplied necessaries, the property will be liable. That is an obligation imposed by law, but no personal liability. Then facts of the case, which is given in question, and finally the concluding paragraph, and then the concluding line. Okay, clear. If you have a confusion in exam whether the answer is yes or no, and you are taking a chance with a 50% more probability, don't mention the concluding line. It is okay. Okay, if there is some error, just hide it, don't show it. So if you are confused whether it is yes or no, don't mention the concluding line. Then no need to mention this, write it inside the paragraph only. Okay, whenever there is something which you need to show, then highlight it. If you don't need to show, goof it around. Okay, clear? So we'll just check any other question of Contract Act. Yes, there is a question again, that is question number 6, first one. Question number 6, first one. Starting with question number 6 first, that is relating to Contract Act. Explain the meaning of, as I have told you, it is important, contingent contract section 31, and state the rules relating to such contract. I have told you, remember the chart. It contains 4 rules in short. Okay, and we are starting with the solution. See, first, contingent contract. Contingent contract is defined under section 31 of the Indian Contract Act 1872. I know the section, I would highlight it. I'll highlight the section. You cannot highlight in exam, but you can underline with the pencil. Okay, so contingent contract is defined under section 31 of the Indian Contract Act 1872. Directly jumping to the definition. Contingent contract is a contract to do or not to do something if some event happens or not. So it is a contract which is dependent on particular event happening or non-happening. So that is a basic definition of a contingent contract. We completed with the definition. You will complete it in 2 statements. Firstly mention the section, name of the act, and then the actual definition, because you need to write the rules also, and the questions weightage is not much. Okay, it is only of 5 marks, and there are 6 rules of contingent contract. See, if it is of 5 marks, 1 mark goes for definition for sure, 4 marks goes for rule. So if you write only 4 rules, it is enough. There is no issue. Okay, so I'll just mention the rules shortly. Give a heading. Firstly, we explained what is contingent contract. We gave a heading, we did underline, and we mentioned what is contingent contract. There is a second question asked, rules of contingent contract. So we'll write rules of contingent contract. heading and underline. Okay, make your answer clear with good presentation. And rules of contingent contract, I'll just summarize. First, it can be dependent on happening. If an event happens within fixed time. So this contract, see, give a heading. Contingent contract can be dependent on an event happens within a fixed time, and inside that rule explain it in one point, that this contract can be enforced when the event actually happens within that specified time. Okay, so if A tells to B, I'll sell you the goods if the ship returns till Sunday. Okay, so it can be enforced if the ship returns before Sunday. Okay, that is the first one. Second, contingent contract can be dependent on non-happening of an event within fixed time. So it can be dependent on happening or non-happening. Okay. Third one is same. When the event happens, does not happen. See, the difference between 1 and 2 and 3 and 4, I have already told you, 1 and 4 is a particularly within specified time. Okay, so if the ship returns in 2 days, that is first one. But A tells B, if the ship returns, I will sell you the goods. Without specifying the time, then it comes in point number 3. Okay, so it becomes void when the event becomes impossible. So in 3 and 4, there is no particular time. And also contingent contract which is dependent to do an impossible act. Then simple, it will be void from beginning. So it will be void ab initio. Also, if this contract is dependent on conduct of a living person, and if something happens which turns it to be impossible. I gave you an example for it, that A tells to B, if I become a prime minister, then I'll do this thing or I'll pay this amount to you. So that is a contingent contract which is dependent on his becoming president. It is not in his hands. Entire public will vote, then he'll become the president. Okay, so that is dependent on a conduct of a living person. And then A dies. So now the contract becomes impossible, so the contract turns void. So that is a contract which is dependent on conduct of a living person. Okay, so these are the rules of contingent contract. You need to mention the heading first, and then inside you need to explain the rule in 1 or 2 lines. Okay, don't just write the heading and come, you will not get proper marks for it. Okay, so there are 6 rules relating to contingent contract, but in exam you need to mention only 4. On a safer side, if you want, you can mention 5 rules. Okay, so this is contingent contract and rules relating to contingent contract. Okay, it is of 5 marks, so 1.5 page, not more than that. Okay, just please be careful. If I know all the 6 rules, if I know the definition, I know the essentials also, I'll write 3 pages. Then you'll miss the questions, the other questions which you know. You leave some portion of BCR which can score you 10 marks or more than 10 marks, and here you will get only 3.5 or 4 marks in contingent contract. So don't do that. Okay, it is not that I have to write. See the weightage and then write the answer. Okay, hopefully you are clear with Contract Act. Next, we are starting with the questions of Companies Act which are covered under MTP November 20. Okay, so firstly, question number 1. Question number 1, second, which is again a compulsory question which is relating to Companies Act. The question they have asked us, PQR Limited is a private limited company and it is registered under the Companies Act 2013 with a paid up share capital of 40 lakh and a turnover of 2.5 crore. Okay, so basic information of the company is given. Now we need to explain the meaning of a small company and examine whether PQR Private Limited can avail the status of small company in accordance with the provisions of Companies Act 2013. See, there are 2 different questions asked here. First, you need to define the small company. If it was not asked also, then also in the provision we would have defined a small company, and then for the current company which is given PQR Private Limited, we need to decide whether it is a small company or not. Now, to decide whether the company is a small company or not, three conditions must be fulfilled. It must be a private company. A public company cannot be called a small company irrespective of the turnover or paid up share capital. Okay, so first condition, compulsory condition, it must be a private company. Second condition, the paid up capital should not exceed 50 lakh rupees. The paid up capital should not exceed 50 lakh. If it is less than 50, for example, in the current situation it is 40, it is okay. If it is exactly 50 lakh, still it is okay. It should be less than or equal to 50 lakh rupees. Also, the power is given to government. They can extend it, they can increase it up to 10 crores as and when they decide. Till now not decided, so the limit applicable is 50 lakh. Okay, so it should not exceed 50 lakh. And the third condition that the turnover in the immediately preceding financial year should not exceed 2 crore rupees. Okay, the turnover of the company in the immediately preceding financial year should not exceed 2 crore. See, here there is a problem. See, first condition, it is a private company, first condition fulfilled. Second condition, the paid up capital is not exceeding 50 lakh because it is 40 lakh. Second condition also fulfilled, but turnover is 2.5 crores and the limit of the turnover is 2 crore. It should not exceed 2 crore, and if the government wants, they can exceed it up to 100 crores by giving a notification, but till date no notification is given, so the limit applicable is 2 crore. Turnover is more than 2 crores. Third condition is not fulfilled, and all the three conditions are compulsory. So here it is not a small company. Okay, so answer is no. We'll just note it down. Starting with the definition of small company. Small company which is governed by Section 285 of the Companies Act 2013. So small company is a company other than public company. Small company is a company which is governed by Section 285 of the Companies Act 2013 and is a company other than public company. So if it is a public company, if in current question PQR was a public company, then it will not be considered as a small company. Okay, so this provision is applicable only to private companies. And second condition, the paid up share capital should not exceed rupees 50 lakhs, and it can be increased if the government decides. It can be increased to 10 crores, but till date there is no notification, so current limit applicable is 50 lakh only. And third, the turnover in the immediately preceding financial year means if you are deciding for the years 2020-21 whether it is a small company or not, then the turnover will be taken for 2019-20, that is the immediately preceding financial year. Then the turnover in the immediately preceding financial year should not exceed, what is the amount? 2 crores. And which can be increased if notified up to 100 crores. Okay, but still date no notification is given, so the limit applicable is 2 crore. And between the conditions there is and. Means all the three conditions must be fulfilled. It must not be a public company. Then turnover should not exceed 50 lakh and paid up share capital should not exceed 50 lakh and turnover should not exceed 2 crore. Okay, and there are certain exceptions because they have asked us specifically what is the definition of a small company. There are certain exceptions to this rule where this provision does not apply. First one, a holding or a subsidiary company. If there is a provision of holding or a subsidiary company, then this rule does not apply. Okay, then the provision of small company does not apply. Also, it does not apply to Section 8 companies. If you remember that those are the companies which are not for profit with a social objective to give benefit to the public. On that also this provision does not apply. And the company which are registered under special act, for example, it is an insurance company or a banking company, so they are governed by the Insurance Act or Banking Act. Those companies also this provision does not apply. So if there is an insurance company given in the question, and if all three conditions are fulfilled, it is other than public, less than 50, less than 2 crore, still it is not considered to be a small company because it is covered by the exceptions. So there are 3 exceptions to small company. So this is the definition of a small company. Our provision is complete. Facts of the case you are already written in the question. It is not more than 2 lines. And final conclusion. What is the conclusion? As per the above provision, first condition is fulfilled. It is a private company, PQR. I'll mention it in short. Applying the above provision to the current situation or current case, PQR Private Limited is a private company. First condition fulfilled. And paid up share capital does not exceed 50 lakhs, but the turnover exceeds rupees 2 crores. The turnover of the company exceeds 2 crores because it is 2.5 crore. So the final answer, will it be considered as a small company or not? No. Answer is yes or no. Tell me. Yes or no. Will it be a small company or not a small company? So answer is no. PQR Private Limited is not a small company. Is not a small company. That is our concluding line. Okay, just note it down. The definition is already given to you. Also it is mentioned in the module. You can get it from there, but the conditions are compulsory. Any of the condition is missing, then it is not a small company. All 3 conditions must be fulfilled. Okay, definition of small company. Done? Exceptions to it and the conclusion. 3 exceptions to it, and the conclusion. Applying the above provision to the current case or in the current situation, PQR Limited is a private company, turnover is, paid up share capital is less than 50 lakh, but turnover exceeds 2 crore. So, it cannot be termed to be a small company. Okay. Done. Going back to the question. So, the question is covering 4 marks. So, the length should be 1 page. 1 page is enough. Okay. And if you define the entire small company with exceptions, it can go to 1 page plus 1 paragraph. No issues. Facts of the case would be small and the conclusion would be small. Okay. So, we are done with this. Next companies are question. Starting with question number 5.2. Firstly, we will read the question. The Articles of Sound Syndicate Limited, which is a public company, empowers the managing agent to borrow both short and long term loan on behalf of the company. So, here the managing agent and the directors are allowed to borrow the loan on behalf of the company as per the Articles of Association. Mr. Liddell, the director of the company, approached Easy Finance Limited, a non-banking finance company, that is NBFC, for a loan of 25 lakh in name of the company. So, director had approached a particular NBFC to borrow 25 lakhs on behalf of the company, which is already authorized by articles. So, the lender agreed and provided the said loan. So, loan is dispersed. Later on, Sound Syndicate Limited refused to pay. Company refused to pay. There is a default. The money borrowed on the pretext, on the condition that no resolution authorizing such loan have been actually passed by the company, and lenders should have inquired about the same prior providing such loan. Hence, the company is not liable to pay such loan. Now, being a third party, being a public, we cannot be aware about the internal management of the company. So, here the doctrine of indoor management applies. So, when we do a transaction with the company, we read the public document, that is articles and memorandum. And in the articles and memorandum, it is mentioned that the managing agent is allowed to take loan on behalf of the company. So, being a third party, I read the document. In the document, it is written that it is already approved. So, I will consider that other internal formalities are already done by the company. So, in such situation, the third party is given the protection. So, the third party cannot be aware about each and every internal transaction of the company. So, here the third party will be given a protection. Here the contention of the director that you should have inquired whether the resolution is passed or not is incorrect. Being a third party, we will assume that the company is duly complying with all the formalities. Okay. So, such case, the decision will be in the favor of third party. Analyze the above situation in terms of provisions of Doctrine of Indoor Management under the Companies Act 2013. Examine whether the contention of Sound Syndicate Limited is correct or not. So, we will just go through the provision. See, there is a rule applicable of indoor management. So, doctrine of indoor management applies. Doctrine of indoor management applies. So, as per the doctrine of indoor management, the person dealing with the company, should have read memorandum and articles, that is the public documents, memorandum and articles, but as far as as far as internal proceedings are concerned. Now, I cannot be aware of the internal proceedings, what the company does in day-to-day life. I can read the document and I can get an idea about the working of the company. So, as far as the internal proceedings are concerned, the third party can presume, this line is very important, the third party can presume everything is done regularly. Everything is done regularly. Okay, so here the third party will be given protection. So if the provisions of memorandum and articles, if the provisions of memorandum and articles are followed, but due to some internal irregularities, there is some internal irregularity which the third party will not be aware of. So, due to some internal irregularities, the rules were not followed. Okay, so due to the internal irregularity, the meeting could not be arranged and so the resolution cannot be passed. Then, third party is protected. And if you remember, the similar decision was made in the case of, which is a very important case. You need to remember the doctrine case of ultra-virus also and indoor management also. That is Royal British Bank versus Turcont. Royal British Bank versus Turcont. In the case, the similar case was there where the director took the loan. The articles mentioned the director can take the loan subject to resolution. Now, being a third party, we will read the article and it is written the director can take the loan, and we would assume that they have passed a resolution for taking the loan, and if they do not repay, we can file a case. So, doctrine of indoor management applies where third party is protected. Condition, they should have read the articles and memorandum. They are not aware about the internal irregularities. So, similar decision was made in the case of Royal British Bank versus Turcont. So, in the current situation, what have they asked? So, in the above situation in terms of doctrine of management, which we have already explained, examine whether the contention of Sound Syndicate Limited is correct or not. So, our answer. Okay, so you will mention the conclusion that applying this provision in the current scenario, the third party has read the articles in which there is a rule, there is a authority given to the agent to take the loan on behalf of the company. So, that is the conclusion. And final concluding line. Whether the contention of syndicate limited is correct or not, answer is no. The contention of the company, that is Sound Syndicate, Limited is incorrect. And the third party means the bank who is sanctioning the loan will be given the protection. So, that you need to mention in the conclusion. Okay, clear? Doctrine of indoor management already given in your Navkar Spiralum module. Still, you can note it down if you wish. Okay, so due to some internal irregularities or rule, if the rules are not followed, sorry, here it is, rules were not followed, then the third party will be protected. This is important. There is some internal problem, then third party will be protected, because third party cannot be aware of each and every transaction done by the company. Okay, and mention the case because it is a similar case, Royal British Bank versus Turcond. And the final conclusion. Contention of the company is not correct. The case, the decision will be in favor of the bank sanctioning the loan. Okay, done? Okay, it is of 6 marks, so you need to write around 2 pages for it. Okay, so first we'll explain the entire concept of doctrine of indoor management. 1 page will be covered by it. Then the facts of the case, which will be covered in 3 to 4 lines. The conclusion and the concluding line. Okay, it is 6 marks, so minimum 1.5 page should be written for it. Okay, clear? Next question of Companies Act is question number 6.3. Starting with question number 6.3, they have asked that whether the following statement are correct or incorrect. Normally in ICAI exam they do not ask true or false, but in MTP they mention true or false, so we'll just go through it. First one, a company being an artificial person, it is not a natural person, it is an artificial person, cannot owe property and cannot be sued or be sued. Company is not a natural person. For example, we are natural persons, so we can acquire property, but company is not a natural person, it is an artificial person, so it cannot own property. Incorrect. That is the basic essential of the company. Company is a body corporate. It is a separate legal entity. So it can owe property in its own name. We can purchase a property in name of the company. Also, it can sue and can be sued because it is a corporate personality. So this statement is false. And they have asked you, please read it along with reason. So we'll give the reason of it. Okay. And second one, private limited company must have minimum 2 members and public limited company must have at least 7 members, which is a correct condition. In private it is 2, requirement of members is 2 minimum, and public it is 7. So this is correct. So it is true. Whether it is true or false, you need to mention the reason. Okay. So we'll just write the answer here only. First one, the reason. First one, firstly write the answer, that is false, then give the reason. Company is a corporate personality, separate legal entity. Therefore, it is capable of owning property, it can own the property in its name, and it can sue and can be sued in its own name. It is not necessary you file a case on the name of the director. We can directly file a case in name of the company. So it is a corporate personality. So it can own the property in its own name. Also it can sue and can be sued. So first statement is false. Second one is simple. You need to mention the same point again. So because it is true. Okay. So second one, the answer is true. The same thing you need to repeat. So as per the requirement of the Companies Act, as per the requirement of the Companies Act 2013, as per the requirement of Companies Act 2013, minimum number of members in a private company is 2 and in a public company is 7. So the above statement is true as per the requirement of Companies Act 2013. Okay, so you need to clearly give the reason. If you just write true or false, you will not get the answer. You must mention the reason in there, whether it is true. Okay, so just go note it down. Done. And the second one, true. Done? Clear? So read the question paper when you give the exam very carefully, especially the practical questions. Read it properly, what they have, what is the condition given in the question with full concentration, and finally what the question is asked. Okay, you need to mention the provision as per the question asked. So if it is a question relating to essentials of contingent contract, then essential must be mentioned. If it is relating to rules, then rules must be mentioned. Not necessary you need to mention everything in the provision. So read the question, what it is asked, it is also important, and the weightage. It is of 4 marks, it is of 6 marks, it is of 7 marks. It makes a lot of difference in the exam. Okay, and in 3 hours you need to spare 2 hours for law. Not just because it is law, but it is of 60 marks. Okay, so you need to spare 2 hours for law, and from it the last 10 minutes should be for the presentation and checking of the paper. Okay, so devote 2 hours for law and 1 hour for BCR. Bifurcation must be proper. Write the paper with full planning. Okay. All the best for your exams. Thank you.
If you like this video, share it with your friends. Subscribe to our YouTube channel to watch more such videos and learn from our expert faculty members. Press the bell icon to get regular notifications whenever we upload a new video. Download NDI mobile app to get complete CA course online. We value your support. Thank you for watching.